Good morning and welcome to PV Legal's daily newsletter. What happens when a bank tries to dress up an ordinary recovery dispute as an insolvency crisis? The Supreme Court of India has just delivered a sharp answer. In Dhanlaxmi Bank Limited versus Mohammed Javed Sultan, the court has firmly told banks that the Insolvency and Bankruptcy Code is not and was never meant to be a parallel debt collection counter. This is Dhanlaxmi Bank Limited versus Mohammed Javed Sultan and others, Civil Appeal number 7184 of 2022, decided on May 7, 2026, by a bench of Justice Pamidigantam Sri Narasimha and Justice Alok Aradhe. The judgment, authored by Justice Aradhe, dismissed the bank's appeal. The court refused to admit insolvency proceedings against the borrower, upholding an earlier NCLAT order. Now, let's look at how this began. The story begins in 2011. A Kolkata company, Emerald Mineral XM Private Limited, agreed to buy an office unit in Synthesis Business Park. Dhanlaxmi Bank sanctioned a loan of 1.5 crore rupees to the company. But here's the catch. Under a quadripartite agreement signed on the same day, the money never went to the borrower. It went directly to the builder. Years later, the property was transferred to a third party. The account turned into a non-performing asset. The bank first approached the Debts Recovery Tribunal, which appointed a receiver and secured a 1.5 crore deposit from the builder. Then, just 8 days later, the bank filed a winding-up petition, which eventually got converted into a Section 7 insolvency petition before the NCLT. 3 issues came before the Supreme Court. First, was this truly a financial debt under the IBC when the money went to a builder? Second, was the dispute at heart a contractual one tied to performance of property transfer obligations? And third, was the bank using the code as a coercive recovery tool while parallel DRT proceedings were already running? The court relied on its earlier rulings in Innovative Industries, Pioneer Urban, Glass Trust, and Anjani Technoplast. The court held that the quadripartite agreement made the bank's disbursement intrinsically linked to the builder's performance. This was not a simple lending arrangement. The dispute was predominantly contractual, and permitted insolvency here would be wrong. The court warned that permitting insolvency proceedings here would convert the code into a coercive recovery mechanism, which is impermissible. The appeal was dismissed. The message to lenders is clear. If your disbursement structure ties recovery to a third party's performance, your forum is the DRT, not the NCLT. Section 7 demands genuine financial distress, not strategic forum shopping. Understanding this distinction is vital for modern banking litigation. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant.